Many of you, for those who I don't know, I'm Jean Sternlight. I'm director of the Saltman Center for Conflict Resolution, and I want to say that I am delighted to see so many of you here. I think this is going to be a really great session, and I'm also wanting to welcome the other crowd that we have up in Reno. Those of you here in Las Vegas can see we have some folks in Reno. Hello, folks in Reno. We welcome you as well. We're Skyping this up to Reno. They can see us, we can see them. They can hear us right now, we can't hear them, but come the question and answer session, if the technology cooperates, we will be in full communication. And we wanted to do that because we wanted to be able to discuss this important topic of court-connected mediation in Nevada with all of Nevada, not just the folks in the South, but also the folks in the North. The inspiration for this talk really came from some local mediators with whom we've been having discussions, and they have said things to us, and the us is myself and Lydia Nussbaum, who's the Associate Director of the Saltman Center for Conflict Resolution. They've just been wondering, as many of us have been wondering, whether the programs that we have here in Nevada for court-connected mediation are the best that they could possibly be. We're doing things, we hope we're doing them well, but we know that people around the country do things differently, and we thought it would be useful to hear a little bit about what they do elsewhere, how it compares to what we do, what are some of the big policy questions that we ought to be thinking about. So to help us have that conversation, we've brought in the person who we think is the best person in the world to help us think about these issues. Her name is Sharon. She's currently the director of the Dispute Resolution Institute at Hamlin's Law School in Minnesota, and she's been there for, 3 or 4 or 5 years. 6 years, whatever, time flies. So she is an academic, and she does the things that academics do, but I think her more important qualification for today is the fact that for many years before that, she was director of Florida's Dispute Resolution Center, and ran that for 20 years or so, and also did a lot of work around the country. She's been the head of national organizations, she's given talks all over the country, for that matter, she's given talks all around the world, and really therefore thought about court-connected mediation not only from the academic perspective, but also from the practical perspective, which I think is a lot of what we need here as well. I know that Sharon is a great speaker because I've heard her speak many times. We were also colleagues many years ago when both of us were in Florida because I used to teach at Florida State. She is the person who, more than anybody else, helped inspire me to get into the field of dispute resolution, so I'm grateful to her for that inspiration. She taught the very first mediation training that I ever took, and I thought it was a good one. So I'm not going to waste any more of the time. I'm going to ask Sharon to come up here. She's going to give her talk and make a presentation, but then we're going to leave time at the end for us all to have more of a conversation through question and answer. So thank you.
Okay, so hello, Reno. I know you can't see me because they actually can only see the screen right now, but we will see them when we get to the question and answer part. So it's great to be here, not only because it's warmer than Minnesota right now, but great to be with colleagues and friends and to talk about a topic that really is near and dear to my heart, something that I have spent a lot of time thinking about and care a lot about. So I'm always happy to talk with people in different places who are thinking about the issues that go into sort of building and maintaining a statewide mediation program. So this is what we're going to go through today, well, the topics. So we'll start by looking at the pros and cons of developing a statewide model. Some possible structures that you might think about, the ever important question of how are you ever going to fund something like this, what are the choices that you have to do it, and then a piece that's really critical to all of this is the qualifications for the mediators. And in addition to qualifications, you really need to think about the disqualifications. And then, as Jean said, we will leave plenty of time for question and answer, and I do hope that we can have a nice conversation about that. So do feel free to jot down your questions so you don't forget them when we get to that portion of it. So advantages of a statewide program? Well, for one thing, uniformity. Inevitably, in a state, practitioners practice statewide. They tend to have a primary practice in one area, but there is a notion of there being something nice about knowing as you go from place to place, you know what's going on. And so that there is a sense of this is the way the state does things. So this idea of uniformity. Clarification of expectations, that if you meet a mediator from Las Vegas, it is not dissimilar to meeting a mediator from Reno and talking about what it is that they do, how it is that they approach their practice, all of those kinds of things, so that clarity around that. Probably more important than all of that, though, is the notion that these kind of services should be available statewide. And so this accessibility for all litigants to have the ability to engage with and to find someone who can offer these mediation services. And lastly, behind the people are economies of scale. That there's no question about when you are organizing this kind of activity, that there are going to be costs associated with, for example, qualifying neutrals. And if you can spread that out over the whole state, it's a lot better than if it is only the province of a single program or community. Okay. So what about the cons? Well, probably the biggest one is, and I know that this state is certainly, and it's an issue, is the state's diverse. And so what is going to work in a densely populated area where you have access to lots of neutrals and access to lots of cases is not going to be the same as what's happening in rural areas. And so there's a real challenge in trying to figure out how do you balance that need for and the good parts about having uniformity and clarity of expectations with the fact that the reality that there's going to be these diverse needs. And of course the biggest thing is the cost. How to fund something that is going to be sort of the collective over the whole thing. So there are lots of different approaches that one could have to a statewide model. The sort of the Cadillac version of it is, I don't even know, maybe there's a better metaphor than Cadillac these days, is the state office with oversight responsibilities and state employees in local jurisdictions. In other words, that the state model is it. They not only govern what the oversight is, but they actually, the state employs the people who are then deployed around the state. Very expensive to do, really rare that you have this kind of model. Second one is, so you have a state office, someplace that's got the sort of that oversight responsibility, technical assistance. Instead of actually doing the work themselves, they provide the technical assistance, but the people really are locally employed or somehow engaged in the activity. And sort of at the far end is, well, you just adopt statewide regulation, you adopt a statewide statute, or somehow figure out a governing structure that this is what people will do, and you don't really provide any state employees or any staff really who have the responsibility for implementing it. So the location of these can really vary. Most often, because of who has the most access to disputes? The judiciary, right? So most often the judiciary tends to be the place where the state office sits, But there's also examples from the executive branch. For example, the Massachusetts program initially was in the Department of Administration. In Ohio, the Commission on Dispute Resolution, or for Dispute Resolution, was a combination actually of the executive branch, the legislative, and the judicial branch. In Oregon, the Oregon Dispute Resolution Commission was a governor's commission. There also are examples where universities housed the state office. So there's really a great variety around doing that. And the scope will often dictate where it is that it's going to sit, which makes sense. You decide, well, what is it going to cover, and then you figure out, well, where is that place that it's going to be. As I said, judiciary, most common, so Florida, Hawaii, North Carolina, Georgia, Virginia, they all have state offices that are part of the administrative offices of the state courts. In terms of scope, you can, focus only on court-connected, or there are examples like Maryland, which does, actually Maryland's more comprehensive, so other examples where they do community. New York's a better example, community and the courts. And then you can have comprehensive, like Maryland, which has oversight over schools and communities and the courts and a whole range of administrative agencies. They really have their finger all over. Although they sit technically in the judiciary, the office, macro, has a very wide range that they do. And even within the court-connected, you can imagine, and several of you are very familiar with the family courts, and that's the most often if there's going to be a particular niche within court-connected, family is often the one where that would be just the scope of the program. Statewide, but just within those kinds of cases. So, again, what's important is to figure out, well, what is the goal of the office? So for court-connected, these are the kinds of goals that people have identified in trying to set them up. The first ones, the first four really, are efficiency goals. They are goals about decreasing size of dockets, speeding cases to resolution, decreasing cost, decreasing demand on judges. So that's one way of thinking about it. But the next four are goals that court programs also have articulated that are important to them, like increasing litigant satisfaction or providing better means of justice, lowering recidivism, the notion that if there's a mediation program, generally what happens, people, when they make the decision themselves, are likely to keep that decision and to do it and to implement it because it's something they can do, and so they are less likely to end up back in court again. We see that in the criminal side, we see that also in families when they make decisions for themselves. Families then tend to figure out how to continue to make decisions for themselves. And lastly, on these sort of improving justice kinds of goals are improving the relationship between the parties. So, but they're not only about courts. So what are other goals that sometimes are articulated? Well, the goal of promoting more collaborative decision-making or decreasing suspensions in the school. When I first got into this field, my first job out of law school was actually working in a New York City public high school. And the program, the mediation program that I ran, had the goal, it was funded by dropout prevention, and it had a goal of impacting both dropouts and suspension and violence in the school. And so that was a very different kind of way of thinking about what was important about the program. There's also providing opportunities for individual and community empowerment, of really, the initial community programs really focused on and had as their reason for being the empowerment of communities, of helping people to figure out how to take control of things themselves. On the agency side, it's often to create better rules or to figure out how they can engage the public in decision making. Decreasing cost of litigation for the state is also another goal sometimes for agencies, and they find that there must be a better way rather than our spending our money in that manner. We already talked about that one. And then this notion of improving procedural justice. I mean, one of the things that we know about procedural justice is that for individuals who have an issue, it's not only the end result that matters to them. What matters to them is what happens and how they got there. And so having voice, having someone actually hear what they have to say, having a fair process is equally important and sometimes more meaningful even than the end result. They will forgive a bad result if there's a good process in it. So that's also an important piece. And I've spent some time on these goals because in creating a state office or a statewide program or a statewide initiative, one really needs to spend the time thinking about what it is that you want to do. Because while these goals are all maybe important or valuable, they can't all be the number one goal. And when they come into conflict with each other, one of them has to be, or several of them have to be the ones that really rise to the top line. And if you haven't done the work to figure that out, it's really hard to implement and figure out what kind of program and how to get it off the ground. And by way of illustration, I would tell you, so I mentioned the Maryland office, which is this really comprehensive office. They actually spent 2 years in a consensus building process with people from around the state who had a range of different ideas about what that state office might do, and developed the consensus before they ever formed the office. And as a result, they've been incredibly powerful in being able to effectuate the goals that they set out for their program. And I also, want to really highlight that the efficiency goals often are the easiest ones for funders to grab hold of, because those are the ones that they can easily say, okay, so this is going to help us save money. But they aren't necessarily the ones that are going to be consistent with the values that underlie mediation. And so in framing up those goals, one really needs to think very carefully about how much do you want to move over towards that efficiency piece, which might help in the short run to get the funding, but may become difficult over the long term. And I'm happy to come back and talk more about that. And in fact, I might take this detour and just say, why is that important? Well, one has to go back to thinking about what is mediation. And most important, and if you look at any of the standards of conduct for mediators or nationally or in states that have adopted them, the number one goal is, and the number one thing that they talk about is the self-determination of the parties. That's what mediators need to be thinking about, conscious of, aware of, and really careful about. And so, in addition to that, you've got this impartiality of the mediator, the voluntariness of the process, which tends to be one of those interesting ones as you think about court-connected, and very, very important that even in the context of court-connected mediation, that voluntariness is preserved. So what do I mean by voluntariness in a court-connected setting where judges are ordering people? Well, that has to do with what happens once you're there. And that it has to be that people have the ability to agree or not. That it has to be okay with them to say, okay, I made it to mediation. In Florida, it was described as appearing. And once I've appeared, I have fulfilled my obligation to the court of having been ordered to do this. But I am not obligated to reach a resolution there. I'm not obligated to reach any particular resolution. And I'm not even obligated to do anything in, quote, good faith. Because Who defines good faith? And how would that comport with my notion of having the ability to say, not for me. I tried, I showed up, but not for me. And so it's a critical element that so underlies what is the fundamental basis of mediation that it really needs to be considered as one considers sort of the big goals of it. The last one is this confidentiality process, and it's in italics because it's not necessarily going to be true in all different kinds of mediations. For example, public policy mediations, if there's any kind of sunshine issue, tend not to be confidential, so it's not a critical element, although most mediations people think of as being confidential within that. So to go back to the point I started to make in terms of the funding aspect of it, so again, might be tempting to go with these real nice efficiency, easy to understand for people, but if funders then expect there's going to be quick results and lots of settlements, you can see how that can pervert what are the basic tenets of mediation. And then if mediators suddenly feel obligated, oh, there better be more settlements, or they better reach resolutions, that suddenly self-determination starts to take a backseat, and maybe voluntariness as well. And so it's one of those things to always keep in the forefront when you're thinking about these programs. So the next piece of it is, how do you go about doing this? What's the best approach to it? Well, you can go a statute, legislative route, and the advantage of going the legislative route is that there's, it's quite comprehensive, and if that is the goal of doing it, there's a beauty to having it, and particularly, even if you wanted to go just court-ordered, the debate as to what is procedural and what isn't, sometimes it's just a cleaner thing to have the legislature say that the courts can do this. The other possibility is to just do it via court rule, and it can be a state court rule. But that's going to, again, be limited to the courts. The courts aren't going to have jurisdiction if you want a program that's going to be, over communities and agencies and schools or whatever. That's not going to work. Same if it was just an agency rule. Or you can just try to do it by practice. In other words, you set up the office and then you voluntarily get people to sort of agree to work together and work consistently and develop a consensus. Obviously, that's the hardest one to keep all together. And then even within the statutory framework, one has to think about how specific one wants to get. So the danger of getting too specific within legislatures, and I don't know how many of you work with legislators, but in my experience in working in Florida, you never quite knew what was going to come out the other side, So it's like you have a real loss of control when you put things into the legislative process. So the least intrusive, the most general is often the best, and then delegate it. As one who worked in court administration, I can tell you we always wanted just, the barest of minimums in the legislation, and then have the courts where we had much greater participation and ability to affect what was going on, to handle it by the court rule. The other thing is that court rules tend to be much easier to amend. You don't have the same kind of process that you have, particularly, so your legislature only meets every 2 years. So if you wind up with an issue, you have to wait at least the 2 years to get it in court, and then there's no guarantee that it's even going to be fixed, or that the fix that you want is the fix that actually comes out at the other end. So it's sort of a double-edged sword there. But there still is, I would say, on balance, having authorizing statute can be quite beneficial for bringing in coalescence around what's going on. And so I think really one way to deal with that is really to have sort of this two-tier. So sort of the general stuff in the statute with all of the specifics delegated to courts or agencies or whatever to do the really development there. So the big question, funding. Well, one thing can be putting the funding in the budget of the entity in which the office sits. So the advantage there is that it's stable funding, it exists, there's a place for it to flow to. The disadvantage is that it is subject to cuts. So if it is part of an agency budget, and the agency or the courts or the judiciary or the whatever it is goes through rough times, it's just built in there and it is quite easy for it to be defunded. So another way to go is fee-based. And Florida was very much a fee-based, and I think quite similar to here. And Gene and I talked a bit about this, that Florida and Nevada share a lot of common, not only the weather, but a lot of retirees, a lot of people who don't necessarily believe that public funding should be a priority. And so fee-based was the way that Florida went. So the office initially was funded in a combination of filing fees, and then once the office took over the certification for mediators, also certification fees for the mediators. And it was in a trust fund. So it was entirely protected. It was protected only for the use of the state office. And then the state office could, the local programs, so the actual mediators, were funded by the individual counties. During the time, sort of at the tail end of when I was there was a major shift in the way the court was funded, and there was a constitutional amendment that said that the court, the state, had to pay for a minimal level of services across the entire state. And so while there had been, similar to here, in the more urban and more wealthy counties, all kinds of services that were available, and in the less wealthy counties, nothing but a judge, because that was all the state provided, it became that they could no longer do that, and that the state had to fund and had to provide services of the same level across the entire state. And when they came up with a list of what those services were, one of the things was mediation. And so the mediators actually, to the extent that they were on staff, became no longer county employees, they became state employees. That also led to a shift in the funding for the state office, and it became much more under general revenue because all of those filing fees became resorted out. But during its heyday, when I was there, I had the great advantage of having a trust fund that funded the office, and allowed for great flexibility for the office to do what needed to be done to create both the growth of the programs and the oversight of the programs. The last possibility, or another possibility for doing funding, is grants. As most people know, I mean, grants are great if you can get them. However, they're temporary. And so it's not stable funding. And so it's not the best way to approach it, although it is a possible way as a start. And then if you can prove the worth of it, then perhaps it might be able to continue on. I want to mention one other disadvantage of the sort of this fee-based. piece of it, because, you know, the advantages are it's independent, it's steady, it's reliable. One other advantage I didn't mention that I like to is, you know, back in the 80s when this new ADR movement started developing, there was this notion, primarily sort of given voice to by Frank Sander, that there should be a multi-door courthouse. And the notion is that the state shouldn't only be paying for judges, because why should that be the only dispute resolution option? That people, when they come into the courthouse, they should have a range of different things that are available to them, and they all should be available at free of charge, just like a judge is. They don't pay for the judge. Now, they pay to litigate, not saying they don't pay, but they don't pay for the judge. And in the same notion, they shouldn't pay for the mediator, they shouldn't pay for the arbitrator, it should all be sort of available at it. And so one notion behind filing fees is it sort of returns to this idea that when you pay your filing fee to the courthouse, you are paying for entry into a dispute resolution continuum, and that those are all going to be available to you. The downside, the really, you know, significant disadvantage, and one that really needs to be confronted if you are going to go a filing fee basis, is access to justice. And what does this do? And at some point, the piling on of filing fees means that people don't have access. And that is something that's really problematic and needs to be very carefully thought through. How much are those filing fees already? What else are they funding? And is that even a possibility? And in many jurisdictions, it's just not, because the filing fees already are too high. The other issue is that there's lots of competition for filing fees. There's lots of other things in the court that are people try to fund in that way. And lastly, if you want to have a more comprehensive statewide initiative, court filing fees really are used by courts. And so less ability really to have sort of this very wide focus. So in thinking about funding considerations, you want to think about how does it fit with those program goals. Is it sufficient? Is it sustainable? Is it reliable? Is it secure? And then what are the limitations of the funding? In other words, the funders, whoever they are they imposing something on the program that just isn't palatable? Again, that comes back to being really clear about what it is that the goals are and what it is you're doing. So the next piece that I wanted to spend a bit of time on is this idea of the qualifications of the mediator. And I want to talk about it because it seems to me that there's a disconnect sometimes where people are willing to engage in embracing the idea that people should be ordered to mediation or any other process, and then they're just free to choose whoever they want, and don't worry, the market will take care of it. And I want to suggest that that is really not a responsible way for the courts to be thinking about it. If there's some kind of statewide expectation, encouragement even, for people to utilize a service such as mediation, then the state can't, and the program can't shirk their responsibilities to identify the qualified mediators. It's important for protection of the consumers. It's important for the integrity of the process. And this goes back to 1989, but SPIDER, which was the Society of Professionals in Dispute Resolution, it merged and became the Association for Conflict Resolution, ACR. But in 1989, they came out with a report, this Commission on Qualifications, which really still has important lessons for us today. So worth sort of thinking through. So I want to just kind of read them first and then unpack each of them separately. So the first notion was that no single entity should establish the qualifications for neutrals. Secondly, this idea that they called it sort of this windshield wiper effect, that the greater the degree of choice the parties have over either the process or the neutral, the less mandatory the requirements for qualification should be. And then finally, the qualification criteria should be based on performance rather than paper credentials. So, coming back to the first one, this really highlights this notion that there should be licensure, that actually mediation the qualifications for the mediator should be different and not be set by one single entity, but that actually, if the courts are using mediators, then they should set what's important for them. If schools are using mediators, then they should be responsible for them, and etc. There's a colleague of ours who is about to publish a very interesting article that is arguing for licensure. And his name is Art Hinshaw. He teaches in Arizona, and one of his arguments is that there was a really terrible case in Arizona where a mediator actually ended up being criminally charged. He's actually in jail now for the egregious behavior that this mediator undertook. And one of the things that when Art thought about this really egregious case, which most people don't even know about, is why don't we know about it? Well, we don't know about it is because there really wasn't a way for people to even go after this guy. I mean, there were several different attempts over a variety of years until finally he ends up in jail. And the reason is because, well, he wasn't licensed to practice law, so he wasn't covered. He was disbarred in another state. That's why he wasn't licensed to practice law. So there couldn't go after him that way. There was no sort of body in Arizona which was maintaining regulation over it. There just wasn't a good way to get at it. And so Art's suggestion is that there should be licensure. I actually don't think so. I actually still sort of subscribe to this notion that there might be good reason for having different kinds of qualifications. Plus, going back to my roots in schools, I think about those wonderful mediators I worked with in high school, and the thought that they wouldn't be able to use the term mediator or call themselves mediator because they weren't licensed to practice doesn't seem right to me. So. But it just shows you that this is still very much a live debate out there. In terms of the degree of choice, it has to do with this notion of the market. But the market truly is a blunt instrument. The market does not tend to be particularly responsive to good mediators and bad mediators. Now, that's not true entirely, but it's not sufficient. And so what we do know is that people don't have enough information to make the choices themselves. And there's plenty of examples, I'm sure you all know of examples, of people who aren't particularly good at mediation, but people still hire them. Either because they like them, or because they have some relationship that they think would be worth exploring, or they don't know any better, and they think that they would be good to utilize. So it does tend to be, certainly one would think it useful, the more that the court, for example, is setting the qualifications, the more that they are telling you who you need to go to, the more that they are saying you have to go to this process over another process, then they should be more responsible for figuring out who it is who should be valuable and accessible and a good mediator. On the other side, we do have to worry about barriers to entry to the field. We have to be very careful about thinking about the innovations that people have made and not cutting them off too soon. Limiting the broad dissemination of peacemaking skills. So you don't want to set qualifications across the board that are going to limit some of that. And of course being respectful to diversity, which there are ways to do that. So for example, you can think about, in Minnesota, there's a Hmong Mediation Center. And the Hmong Mediation Center was created specifically to address that community where this notion of having a true, neutral, impartial, who had no knowledge about anything about the individuals or the dispute really wasn't culturally appropriate. And so there was a way that recognized that there could be Hmong leaders, elders, respected by the community, who would have mediation training and understand how to utilize that process, but also be culturally appropriate. So those are things that one can do when you have these different entities that are involved with it. I'm going to come back to the paper credential piece of this because of the performance. Because performance-based criteria, very, very difficult to implement. And so I want to talk about it when we talk about the qualifications. Mediators, of course, can be what we call in-house. They can be staff. They can be salaried, they can be full-time, part-time, they can be contract mediators, range of different ways that you can go about doing that. They also could potentially be private providers that are paid by the parties. All of that is possible within the realm of it. And not included there, but really should be, is volunteers. Because of course that is a possibility. And again, in a retirement state like you are, certainly in Florida, that was a major source of mediators, particularly on the small claims level. People who wanted to give back, people who were willing to undergo training, and to spend some time in the community. So, if we look at possible qualifications, let's take some basic ones and kind of work through them. Training. Almost everyone agrees that if you're going to qualify mediators, that the one thing that they must have is mediation training. Interestingly, not everybody specifies what should be in that mediation training. They just say they should have training, and sometimes they'll specify, oh, it's 30 hours, or it's 40 hours, or it's 20 hours, or it's whatever number of hours, but nothing about what the content has to be. One of the things that Florida did in adopting qualifications and adopting training as a qualification was also to adopt extensive qualifications about training. Who the trainers were, what their experience was, how they taught the course, things on pedagogy, as well as very specific learning objectives that had to be included within the training program. So that it wasn't just generic, take training, but very specific also that there had to be role plays. And not only that specifying there had to be role plays, but specifying who had to watch those role plays and what kind of critiques they had to provide. So getting down to that level of specificity to ensure that what's happening in that room is actually going to get out what it is that you want from the training. Another thing to confront is it general training or is it specific? So, for example, in Florida, there were 4 different types, and then 5 different types of mediators that you could qualify as. It was a circuit civil, which were civil cases over 15,000. There was county, which were the civil cases under 15,000, primarily the small claims. There were family, which were the dissolution. There were dependency, which were the abuse and neglect cases. And then there were also appellate mediators. And if one wanted to be a mediator in any of those categories, categories, one had to take a specific training for each of those categories they wanted to be approved. There wasn't one that you then did an add-on. So different places do that differently. Minnesota, they allow for what they call a bridge program. If you take the basic civil program, you can do a bridge program, shorter program, and add on a family. So those are choices that one has to make. But in any case, everyone believes it's important, even though, in terms of empirical evidence, not entirely clear that training actually does what we want to believe it does. Nevertheless, it is considered to be sort of the core qualification. Apprenticeships or mentoring. So one thing that we do know that does make a better mediator is experience. And so one way to ensure quality of the person who's going to eventually be the mediator is to provide some ability for them to get experience. The community programs have known this for years and do a fabulous job of mentoring people. In a community program, once you take training, you never get to just immediately go out and fly solo. You always are paired up with people, they observe you, and then maybe you observe something, you're observed until you are deemed to be ready, and then you get to do your mediations yourself. Because mediation has become sort of this private market, and people pay for training themselves, it becomes a little bit more difficult to dictate this kind of apprenticeship or mentoring. And again, I'll go back to Florida because we tried there to implement a requirement where people had to do a mentorship. And there were all kinds of difficulties that we ran into. So, for one thing, who was qualified to serve as a mentor? Is everyone qualified to serve as a mentor? Well, you know that not everyone is a good teacher, right? So even people who are great at doing something may not be good at helping someone else to figure out. And then you have the issue of, well, if the parties are paying for the mediators, let's say in the civil cases, we'll leave family aside where you've got some people who are on staff, and the parties are paying for the mediators, they want somebody else to come who's inexperienced to do it? No, they hired this person to do it. They're not going to have someone else. So how does someone get in the door? And then we had issues where people, it wasn't in their best interest to mentor new mediators. If they're in private practice, and they invite more people to mentor with them, and now they are seen as good mediators, well, now they just created their competition. So there was all kinds of things that made it very, very difficult. And what Florida ended up doing was keeping the requirement, making it an ethical obligation for people to take mentees in, but not making them any kind of gatekeeper. So in other words, the mentors strictly were there for experience, to provide experience, but not to comment on someone's ability to do anything, not to suggest that they need to see more or do more experience like the community model was, where they would sort of assess whether you were ready to take the new one on. Instead, merely to make it a hoop to jump through. So it's valuable, it's difficult to implement unless you have employees, unless you have people who have a steady stream of cases that they are willing to share with the people who are coming in, and then have the ability to share that experience with them. Educational background, professional experience. Well, what we know is that it is not at all correlated that lawyers create either more settled that people who participate with lawyers in mediations have a greater sense of perceived procedural justice. So, and that tended to be the educational background that people went to. That if they were going to say, well, you know, who might be a good mediator? It's like, okay, well, a lawyer, or a retired judge. Now, retired judges, even less likely, if you think about it, to be a good mediator, because, not to say that there aren't some wonderful former judges who are mediators, but it's as a general rule, judges have spent their life telling people what to do. So it's not exactly a smooth transition to go to, oh, and now I'm just going to help to facilitate a conversation and help people figure out what they're going to do. So that's a bit of a problem. On the other hand, what we do know is in terms of institutionalizing a program, the quickest and easiest way to get acceptance of a mediation program, get the lawyers and the former judges to be mediators. Because that's who the current lawyers and the current judiciary feel the most comfortable with. So it's a real dilemma there. I will mention that there also in the family area was, for a period of time, a consideration of not just lawyers, but also mental health professionals, people who, in Florida, even the first qualification rule for family was lawyers with 5 years of practice, or mental health professional, or people, accountants, public accountants, CPAs, because they would have the ability to handle the tax consequences of the divorce. Now, there wasn't any bifurcation though, so that they weren't only allowed to do the financial piece, so they would equally do the child-related issues. So, needless to say, it underwent some criticism that maybe those weren't the best qualifications. A couple of years ago, actually, shortly before I left, the Florida Supreme Court Committee on EDR Rules and Policy submitted a petition to the Florida Supreme Court and changed the qualifications to a point system, which recognized that there were a range of ways that one could get sort of this package of experience that might be useful. And so it went totally away from these specific educational backgrounds, but that was just one of the ways that you can achieve points, but you also could achieve points by experience as a mediator in other kinds of mediations, more mentoring, additional training. So there were a variety of different ways to come up with a package that would enable you to meet the qualifications. One other thing to note in terms of the background, relying on educational background, that it does have an unintentional impact on diversity. Particularly, you know, if you think about, again, Florida's initial qualifications were lawyers who had 5 years of Florida practice or retired judge from any U.S. jurisdiction. Well, the U.S. judges from any U.S. jurisdiction, when it was adopted in 1988, well, who were judges? I mean, they were not a very diverse group. If they were already retired, remember, you know, maybe, you know, those coming in were more diverse, but the people who were retiring, so it was almost exclusively a white male group, and the lawyers who were at that point in their career often were less diverse, and including, I mean, gender-wise. So it was never the intention to have that restriction, but the initial group of mediators was wildly undiverse. Okay, performance-based testing. So performance-based testing has been tried. Boston did it for a number of years. Maryland does some, and still to this day, the Institute for the Study of Conflict Transformation does performance-based testing. Very expensive and very difficult to implement in a positive way, and particularly difficult to implement if you think about it on a statewide basis. Because on a statewide basis, you have to be able to prove that it is completely unbiased, non-discriminatory, and fair. And the problem with performance-based testing is it is inherently, it's the beauty of it and the problem, it's subjective. And that's why it's good, but that's why it's bad. And that's why it's so difficult to implement, particularly on a statewide basis, so that you can really validate it and make sure that it's going to be what it is that you want. It also requires great clarity as to what your definition of mediation is. Because if you're going to do performance-based testing, you have to be very clear. Do you allow people to be evaluative? Do you allow people to be transformative? Or does anything go? And if anything goes, then what are you really basing it on? So it's a very intense process in order to design something that's going to be effective. This is something new that different places are starting. Georgia is experimenting with an ethics test, and so is California, where in order to qualify, you have to pass an ethics test. Florida went one step below that. They said the trainers have to pass the ethics test, because they're the ones who are teaching the ethics, and they better know what it is, but they're not going to require the mediators actually to take the ethics test. Good moral character. So Florida does require this to be a mediator, to be qualified as a mediator. It's an ongoing requirement. One of the things that they look to is criminal background. It does require reporting. So one of the ways people get in trouble is by not reporting something that was in their criminal background, that shows up on their criminal background. But one of the things that it has enabled Florida to do is to make sure that mediation, qualified mediators, don't become the sort of the ground for people who were disbarred or who were unable to do something because of other criminal issues. Another example is these are real examples of a mediator who had domestic violence criminal charges, not charges, criminal conviction, and wanted to be a family mediator. Not exactly a great fit. So if you don't have something like this, you really don't have the ability to say, no, somebody can't come in. There are definitely issues with it, but something to consider. And then continuing education. And if you're going to do continuing education, then are you going to monitor the continuing education? Does anything go? Can anybody just say, I'm doing continuing education and then it counts? Or is it going to be something that is monitored and that has to be applied for? Will there be specific requirements? The big, very controversial decision in Florida was when all mediators, not just those doing the domestic relations family cases, had to do domestic violence training. Because it can come up in other situations. It can come up in, for example, a business dissolution or something else. So it's not only in, or non-traditional families end up in civil court. They don't end up in family court. So domestic violence was required for all of them as continuing education. Last one I mentioned is peer review, and it came up this morning. That's another way, not really a qualification, but a way of sort of this ongoing. So if you're going to qualify, I said you've got to think about the disqualification. Clear set of ethical standards which are enforceable. If you're going to disqualify anybody, there's got to be clarity as to what those qualifications are. A grievance system that has due process for the mediators and ease of access and accessibility for the complainants so that they actually know about it, they can access it in a way that is easy for them. And then accessibility for the mediators to find out advisory ethics. Again, this role of the state to provide education. Lastly, some continuing obligations. Research. Those of you with me this afternoon know that we have a real dearth of research. So if you're going to have a statewide program, I encourage you to consider how to build in research opportunities to do that. Mechanisms for reevaluation and ability to implement change. It's one of the things I'm most proud of what I was able to do in Florida, along with the Florida Supreme Court, was to have institutionalized mechanisms of constant review and constant change. You're not going to get it right the first time. You've got to figure out ways that you're going to be able to revisit and change. And then lastly, this dissemination of ethical and other issues for continuing education. So once again, I spoke longer than I intended to in this part, but I'm going to stop there and open it up for questions both here and in Reno. And so I think we're going to swap it out and we're going to get to see them big. Right? Yeah, there they are. So, hello Reno. Oh, good. So yes, first question here.
You said something that as a employment lawyer who represents employees said the hair on the back of my neck.
Oh, okay.
Culturally appropriate mediation. And how does that balance with the principle of equal justice under the law? I don't know anything about the Hmong culture, but I am aware of certain jurisdictions giving the imprimatur to Sharia law mediations where the rights of women are not respected to the same degree that they are under U.S. law.
Mm-hmm.
And as an employment lawyer, I would love to sue a state that officially allowed that as part of the mediation program. So how do you balance that to assure equal justice under the law when some of these outsider cultures are not respecting the rights of especially women to the same degree as U.S. law?
Okay, so I need to summarize that just so to make sure that those in Reno can hear. And so it's this question about how do you, in the context of culturally appropriate mediation, how do you ensure that there's equal justice under the law and that there's really respect for what is the U.S. law?
Yes.
Well, so the interesting thing about mediation is that mediation people can make resolutions and make decisions for themselves that they want to make. That they're not bound by the confines of what the law would say. So, but it is, I think it is a very valid and challenging question for what is it that we hold to be that you have to do versus what is it that people want to do and are going to allow them to reach a resolution. And in the context of the Hmong Mediation Center, it had more to do with who was allowed to come in. So for example, when a family is going to get a divorce, it's not just about the couple. It's about their families. And they all have a role to play in that conversation. It's more like what we commonly think about in terms of restorative justice and community circles and things like that. And so how to make space for that in a way that worked for them culturally. Now, in terms of what their responsibilities were in terms of child support and things like that, no, they weren't allowed to make their own decisions that were going to be outside of it unless they could explain to the judge why it was that was to be appropriate, in the same way that parties here in the mainstream who go through a mediation can deviate, but then they're going to have good reason to be able to explain it. So hopefully that made the hair go down a little bit on the back of there. So, no?
Didn't go up anymore.
All right, well, I'll take that.
So just by way of logistics, I wanted to invite the folks in Reno, if you have a question, you guys have a microphone that's up in the front of the room, so if you go up and take the microphone, we will let you ask questions. And if you here in Las Vegas would like to ask questions, just raise your hand and I'll bring you the microphone so that Sharon doesn't have to repeat all the questions for the folks in Reno. Questions?
And this may be more than what you want to get into, but the title is statewide program. Are you suggesting that there be a statewide program to govern mediators no matter what field that they're in? Are you saying there may be a statewide program for civil and a statewide program for family? What is it you're proposing, and how would you get around the differences between the rurals and the larger counties?
Yeah, so I do think that if you have a statewide program, whatever the statewide program encompasses needs to think about the qualifications for those people who you are including in it. So if it's a statewide program that is exclusively family, then that's the only mediators that you need to worry about regulating. If it's a statewide program that's about all kinds of who are connected, and you want to have different qualifications for each, which I actually think makes some sense, then you better figure out what those qualifications for each one are. Is that responsive?
For the first half. The second half is how you overcome the differences in the rurals. You're not going to probably find anybody that meets the qualifications we'd like to have in the larger county.
Okay, so the difficulty between the rural and the urban, and what happens if you don't have people who are going to meet those qualifications. So, so first of all, I wonder whether that's really true, that there's not going to be people who would meet those qualifications. So I'd be interested. I mean, I don't know enough about the state to know if that's really true. I know that my experience in other places is that, you know, like good old supply and demand, that when there's a vacuum and there's a need, people will go to fill it. In some, you know, in the early days in Florida, there were people who would ride the circuits, and they would go to rural areas. Eventually, I mean, it really did even out, and there were people who were willing to and available to do it. I think the more common problem that happens in rural areas is that the people who are qualified, you don't have that same 6 degrees of separation or whatever, or any separation. In other words, that everybody knows each other. And so the notion that you're going to find somebody who's truly an impartial person to help out, probably that's the part that one has to think about, how you think about that, so that it can encompass and work both in that situation and in the other. And I think there are ways to write things and then also, you know, sort of share the commentary underneath it that would enable you to bridge that. That's at least, that was my experience in Florida.
Hi, I've got the mic, so I guess I'll go next. Of the states that you have studied who have programs, I'm curious as to where the genesis or where the impetus for the creation of the program came. Did it come from the court? Did it come from the bar? Did it come from some community? Here in Nevada, we've had a very successful, long-standing appellate mediation program that started with the court, and a foreclosure mediation program that started with the court. There were other programs that were created through the legislature that have had nothing but changes and disruption because the legislature, the genesis was someplace other than the court. So I'm curious as to what successful programs that you've seen elsewhere, where was the impetus?
Yeah, almost all of them have a very strong impetus from the court. That you know, a really visionary Chief Justice, or you know, Ohio had a Chief Justice, Maryland was a Chief Justice, Florida, that really had a conviction and a willingness to use the bully pulpit and create a energy amongst the legal community that this was something that was important to do. But lots of the successful programs also have sort of this, you know, it comes from all different sides, and then there's a coalescence around it. In Florida, there was actually the Dean of Florida State University Law School, Sandy Dallenberg, was very instrumental, and he's someone who had been very instrumental on a national level about thinking about dispute resolution at the same time that the justices were interested in doing it. And interestingly, the bar was completely absent from the discussion. They were like very late to the party. And it wasn't until things started going that they realized, oh, wow, this is really going to happen, and we better pay attention to it. And then we're a bit less embracing of it initially because they hadn't started with it.
As you've heard from the questions that you've gotten already, and as we've discussed over the last couple days, we have really a highly decentralized system, if you could even call it a system, here in Nevada. This is really a follow-up on some of the prior questions, but knowing that if we were to try to centralize any part of this, what part do you think makes most sense to centralize?
Well, I mean, so you already have a fairly well-developed family program, right? But I don't know to what extent is it centralized at all? Is it?
It's not. Are you talking about across the state?
Yeah. So is it, but does it exist elsewhere?
You'd have to ask that.
So, so what's going on in terms of family mediation in Reno? Or in your county?
Go up to your mic.
Someone tell us. I see the mic sitting there. Someone coming? Or two people? All right, thank you.
In terms of family in Reno, we do have the mandatory custody mediation that goes through the courts. So that's definitely a program. We also have a dependency program in Reno and a guardianship program, pilot program. As far as divorce mediation, there's no centralized program for that. That's really just done through private mediators.
So it's happening, but it's not, it's private mediators.
For the divorce,
Yeah.
the custody, dependency, and guardianship, there are court programs.
And when you're differentiating between custody and divorce, you're saying the
Financial
aspects.
Yeah, the non-custody piece, even child support is not handled through our custody, the court-based custody mediation.
Okay. So, I mean, but it sounds like that's a place to start, is to have the family mediation groups talking to each other and really investigating whether there's value in coordinating and developing some consistency and, you know, building on the lessons learned from one from the other. And you know, maybe some shared continuing education or things like that. What's the distance between here and there?
8-hour drive.
Wow.
That's a fast track.
Yeah.
Oh, okay.
So there's an airplane.
And is there, do people, so the state doesn't really, what does the bar do? Do they get together?
Yeah, in the middle of the state, because nobody wants to.
Yeah, in the middle of the state too?
Right. In the family law right now, we have the anti-theft law conference. It's held mid-state because the north doesn't want to travel south and south doesn't want to go north.
Well, I mean, Florida was not dissimilar in terms of, it's not as big of a state, but it's a really awkward one to traverse because it's, you know, just long, it's like an L. And so from, you know, Pensacola to Key West is like 10 hours or more or something like that. But, and so Orlando, I mean, people, that's, you know, people tended to meet in the middle of the state. So if there is anything in the middle of the state, just yes, you need an Orlando. You need Disney to come back.
answer this question. When I was working here at the law school, I sat on I can't even remember it was like the outreach or outsourced mediation committee. This is basically trying to have certified mediators available for the courts to refer to. They had very high bar.
Of qualifications.
Yes, very high bar. The problem was that when I sat on that, I just was like, where do you have to get these trainings? Because they're not in the state. And they would have to go to California or someplace else. What did Florida do when they decided to set qualifications for mediators? How did you have the programs there for the trainings?
Yeah, great question. So the very first trainings that were done were paid for by the state, and they were done over the summer, and then people were invited to come to them. And so the first 150 people that were trained, some of whom had already been mediating for years and years and years, but because the new qualifications were going into place, and so that everyone had to take a certified training program, and this was going to be it. And so that those first approximately 150 people, the state provided the training. And then used that as the prototype to develop what the training standards were, and then basically put it out there and said, private providers, if you want to meet these qualifications, you can apply to offer the certified training programs. So, and then it became a private market, and needless to say, it took off. Once it was the private market. But the initial one was done, was funded by the state.
Has any jurisdiction tried criminal mediation with victims?
Yes, absolutely. Although, I'm not sure. Now, Maryland does it, but I don't know how much it is on a statewide basis. So, Lydia, you may know about whether Maryland, because I know criminal is included.
So Maryland's program that focuses especially on juvenile offenders. They actually use a community conferencing model. It's not necessarily through which Macro has also helped fund this ADR wing of the Maryland State Judiciary. And so it's a slightly different dispute resolution model. And the big debate there was whether or not the restorative justice process should be pre or post adjudication. And there was a lot of work to make sure that the process was pre-adjudication, so that it wasn't coercive for people. But yeah, it has been tried, and
yeah, it's definitely tried. The question is whether it's it doesn't seem to be as statewide. A statewide model. They tend to be more individual programs.
Well, and also especially with schools. You had mentioned your work in New York. A lot of school counties are using restorative models to reduce peer violence and vandalism and property crimes that are happening on school property, so that the police aren't the first interveners, that there are other people on staff to do that.
I had that exact problem with trying to acquire the training. I had to travel all the way to Jacksonville because the curriculum here required that you needed at a minimum 40 hours, actually no, it was 50 hours, I believe, classroom time. And the closest I could find to that was Eleanor Robbins' training. So I traveled out there for a week to get the 40 hours, and I still had the hardest time trying to put the rest of the packet together. So, and the gentleman mentioned, there's this committee. The furthest thing from this committee was putting together the education component before they put the qualification requirements together.
Well, it's just so amazing because I have to tell you that in Florida, the entrepreneurs just totally took off with this stuff, and so it's just amazing that there haven't been people who say, I can do that training.
It's a smaller market. There's a whole lot more people in Florida than there are in Nevada. So I think it's just that there aren't, and there isn't yet that much demand for mediators, so the mediators don't have as much incentive to
Well, you know,
look
the
at
demand for mediators never was a impediment for people taking the training. They maybe should have been, but it never was.
So there, in Nevada, there's a funding stream or a funding philosophy or NRS that funds community mediation for counties of over 100,000 or something of that effect. So it's not all about family mediation. There's still community mediations. And there's still counties in Nevada that do not have mediation centers that have mediation needs. And in those rural counties, the judges aren't actually lawyers. So these communities have done what they needed to do to establish the legal process, and they could surely establish mediation processes. So I'm just trying to bring that to light, that it's not all about family mediation.
Yeah, so I mean, and thank you. I mean, I think that that's, the community mediation is really the foundation of where all of this started. It really is the roots for all of this, and so that's wonderful to hear that it exists, and truly that can be a great way to provide those services for those rural counties, because particularly if you've got the community basis out there.
I don't see any more hands here in Las Vegas, so unless somebody in Reno wants to walk down to the microphone, I think we're ready to remind everybody in the audience to fill out your evaluations, please, so we can get good feedback on this program, and especially, please, in Reno, if you'll let us know how the Skype thing did or didn't work, we'd be very grateful for that. And let's give a huge round of applause to Sharon Price. Thank you so much. And a special thank you for the technical people who did seemingly make this possible, and I know it worked pretty well from our perspective. Thank you so much.